But you feel at this point, this offer is something that you should take because it's in your best interest.
I do.
Have you had enough time to talk to Mr. McKinney about that and have him explain those things to you?
Yes,
And you're comfortable doing this and it's good for you at this time?
I am.
And is that based upon what the offer is?
Yes, sir.
Okay. And with that, has Mr. McKinney answered all your questions about the plea and how it affects you?
He has.
You satisfied what he's done?
Yes.
Court will find the plea to be freely and voluntarily entered into and accept the plea. How much time do you think you need to get the fees and costs paid? Is a year enough?
About a year and a half.
Okay, a year to pay. And if you need more time, as long as you're paying, I'll give you more time, okay?
Okay, thank you.
All right. I'll find the plea freely and voluntarily and accept it. All right. So I showed Donahue was continued, correct, Madam Clerk? Now, Mr. Stewart, you're here on Klettheimer, right?
Yes, Your Honor.
But my notes indicated that we're here for the motion to dismiss today?
That's correct, Judge.
All right. And I guess I've got Mr. Anderson, and then Mr. Pippin with Mr. Catalinic.
And Mr. Glenn Smith came back at 2.
Right. And so with Mr. Pippin, what are we doing, Mr. Catalinic? I'm just trying to figure out triage here who we can get done quickly.
Your Honor, that's sentencing.
Say again?
That's sentencing, sir.
Okay.
He already pled to the VOP.
Oh, that's right, okay.
Yes, sir.
And then we've got Lacoste with Mr. Early.
And Judge, there's Philip Lazinski with Mr. Cochran.
Right.
There is an expert on Zoom for that case that's expected to testify.
Okay. All right. All right, so Donahue and Lacoste were canceled? Okay. So Lacoste was canceled. So was continued to another date or just removed? Okay.
What case we talking?
Lacoste.
Yes. Oh, okay. I know Donahue was, we confirmed with Mr. Fowler's office that it was canceled.
All right. Mr. Stewart, let's go ahead and get your motion to dismiss done on Klettheimer, please.
Did you have yours? I'm sorry.
Your Honor, did you want to address this at council table or at the lectern?
The lecture's fine.
Very good. May it please the court, Your Honor, Brad Stewart on behalf of Mr. Klettheimer, Judge. For the record, this is case number 2025 CF 1824. We are before the court with regards to our motion to dismiss relating to statute of limitations as barred, Judge. I believe this is going to be ultimately purely legal argument, and our position is that the state bears the burden of proof and believe that they should have the floor at this time.
Yes, Your Honor. In looking at this, I mean, to be quite frank, there is not an abundance of case law in regards to bigamy and the statute of limitations. And so in looking at this charge, I think the main case that was even kind of close to being on point that was cited in the defendant's motion was Toro. And so I first want to address that case. In that case, there's quite a bit of interesting timeline. We have, I'm going to call it wife one. This guy actually had quite a bit of wives, but wife one was married in 1988, divorced in 95. Wife two in 1990, divorced in 94. And then wife three was married, I believe, sometime in 94, 95, and then was the subject of the initial action in that case. Shortly before they go to trial, the state files an amended information and adds in count one as being wife two, which is the wife from 1990 to 1994. And they also, there's some Williams rule. Toro isn't necessarily about the statute of limitations in the sense that the majority of the analysis doesn't have anything to do with that. There's about a paragraph, not even, where it talks about what happened with count one. And I say paragraph in that it talks about the date ranges of the marriages, and then it states that under count one, it was ultimately dismissed for statute of limitations. I went into the Broward County Clerk of Court trying to get any information that I could in regards to that amended information for our argument or our argument's purposes. I also want to point out that bigamy does have a victim. And so to argue that bigamy is a point-in-time offense, meaning that the day of the marriage is when it starts to run, the state would argue that that can't be, because at that point in time, if there is an element of fraud in this sense, when a victim doesn't know that that person is already married, there's no possible way for it to be reported unless the person who is committing the bigamy were to turn themselves in. And so because of the presence of a victim in that, the state feels as though once the victim knows that a crime has been committed, that is when the statute of limitations would start to toll. This isn't like a possession of a controlled substance case or something of that nature where there's no victim and the crime occurs at one point in time. The state would also argue that bigamy is not a point-in-time offense. It's a continuing offense that is ongoing until that person is no longer legally in two marriages at one time. I also, given the state's argument, the stance that there is an inherent element of fraud to bigamy, in particular the 826.01, when one party is not aware that they are entering into a bigamous relationship, we feel as though the extension under the statute of limitations in 775 would apply here, and that once the victim in this case, Ms. Whitley, found out about it, that would be the earliest point in time the statute of limitations would start running. And I think under the defense's motion, that would have been November 22nd of 2022, meaning that once that day when she discovers that there is a bigamous relationship and that she was the victim of bigamy, at that point would be when the 3 years would start. And so we did file, I believe, in October of 2025, which would be inside of the 3 years. I would also like to point out, as I had stated in my demurrer, that the victim had no idea that it was a crime until the day that she actually reported it. Once she found out that it was a crime, she then went and reported it. Law enforcement took some time to actually investigate. It was over a month, and then ultimately leading to the arrest of her sometime in August. And so from the state's perspective, we feel as though our argument is that there is an inherent element of fraud that's present in bigamy when one party is entering into a relationship and the other party has no idea that they're already married. And that because of that fraud, because of that lack of, the impossibility of that victim knowing at that time that a crime had been occurring, I mean, to put it another way, had this marriage gone on for 20 years, and then they find out 20 years later, I can't believe that our statutes are crafted in such a way where there would be absolutely no recourse for entering into a bigamous relationship. If the victim of that crime didn't know that they were the victim of a crime until 20 years down the road. And so because of the inherent element of fraud that is present, particularly in this set of circumstances, we would respectfully request that the court deny the motion to dismiss and allow this case to proceed forward.
Thank you, Your Honor. The problem with the state's position is that's not what the law says, very candidly. Before I get into that, Judge, I want to start by laying out two main principles as it applies to the overall statute of limitations. Number one, when a criminal defendant challenges prosecution as untimely under the statute of limitations, the state bears the burden that the prosecution is not barred by statute. It's a very clear principle, well established, as cited in my motion. Judge, secondly, statute of limitations in criminal cases are to be liberally construed in favor of the accused, and any doubt regarding the timing of the offense must be resolved in the defendant's favor. I want to cite Clements, 979 Southern 2nd, 256 for the record in that regard. Judge, it is against that backdrop that we look at the statutory framework and the case law surrounding this. I do agree with the state with regards to the overwhelming absence of any direction as it relates to bigamy. So we look at the statute, and then we look at the case law, read those in tandem. What do we have? Statutory framework, 82601. As the court knows, Mr. Klettheimer is charged with the crime alleged of bigamy. Elements thereof, having an existing spouse that is living and marrying another person. That's it. There is no standardized jury instruction because the statute is very clear and very plain. This constitutes a third-degree felony with a 3-year statute of limitations under 775.15, specifically sub 2 sub c. The bigamy offense is complete when both required elements occur. That has been the law for over 100 years according to Davis v. State in 1918. This is the oldest case I've ever cited. Davis states the second marriage constitutes a gist of the offense and must be laid with particulars of time and place in order to show the defense is not barred by limitations. And this is ultimately the question, Judge, is the state is arguing this is not a point-in-time offense, which I believe Davis and Toro suggest strongly otherwise. They are arguing this should be a discoverable offense. And I'm going to get to that issue in a moment. 775.15 sub 3, Judge, does provide us with a little bit of guidance. An offense is committed when every element has occurred or the legislative purpose to prohibit a continuing course of conduct plainly appears in the statute, which bigamy is not anywhere in 775.15 or any of the other extensions therein. Of course, we discussed Toro, Judge. I think the best way to describe the defendant in the Toro case is a serial bigamist. I believe he had three allegations of bigamy in this, prosecuted for one. What Toro, however, does tell us is that the court granted the motion to dismiss for statute of limitations as it relates to the amended information that was filed on the marriage that occurred in 1990. Prosecution was held in 1995, clearly outside of 3-year statute of limitations. The interesting part of Toro is that the wife, in this instance in which he was married to from 1988, said that he was, the subsequent wife indicated that she was told that he was divorced, fraud in the inducement to marry. That case involved an element of concealment and fraud. The DCA declined to extend any fraud exception to the court's ruling. I think that is critically important in this case. Judge, I also want to point out that Section 826, again, we're charged with bigamy under 826.01. The legislature contemplated 826 in the inclusion of discovery-based provisions of 775.15 because we find the crime of incest included in there in 775.15 sub 13 sub A. The legislature clearly reviewed 826 and picked one out to say this is included in the discovery-based provisions of this exception to the statute of limitations. Had the legislature intended to include bigamy in the discovery-based provisions, it would have done so. Judge, utilizing the statutory construction rule, expresso unis ex excluso alturis, the legislature lists exceptions, others are excluded. Bigamy is not a part of the fraud exceptions, therefore it is excluded. I also want to point out, Judge, in terms of the state's argument with regards to inclusion of 775.15 sub 12 sub A, it fails for 2 reasons. Number one, it would require an element of fraud, and number 2, a aggrieved party cannot be a party to offense. Bigamy has no material element of fraud. As stated, again, we have the elements very clearly laid out by statutory construction. Have an existing spouse that is living, marrying another person. That's it. There is no fraud There is nothing to read into this other than the plain language the legislature has given us. Any exceptions do not apply. Had it intended to, the Toro case could have carved out that exception or sent it to the legislature for review. It did not. We can't read elements into the statute that are not there. That is not our job. Second, a aggrieved party cannot be a party to the offense in order to seek relief under 775-15 sub 12. Judge, we call this the clean hands rule under the fraud exception. In this case, in this particular case, this individual knew of the alleged bigamous marriage 3 months after they were married and continued in the marriage. It could be considered a conspirator, suggest a principal. By stating in the text message attached to my motion with regards to Exhibit A, quote, "Well, baby, if we're not married, we'll not tell anyone, including the kids, and get married again." The state argues she didn't know. There should be an exception. Ignorance of the law is no excuse. We tell criminal defendants that all the time. That is not an exception that applies to an alleged victim who knew and did nothing until 3 years later. Specifically after an annulment was filed, and then 4 months after that annulment, when Mr. Klettheimer did not agree, she then attempted to weaponize the judicial system by filing these charges. Judge, against the backdrop of the state bearing the burden and the statutory construction to be liberally construed in favor, this time period falls squarely outside of the statute of limitations. The state is absolutely barred from prosecution. They offer this court no statute or case law that directly supports their position and should not be afforded relief as it relates to this. I request the court will grant our motion to dismiss.
Okay. In reading and listening to the argument, when are you alleging that the statute began to run?
It's a point-in-time offense, Judge. So
you're alleging that it began to run when they were married?
August 20, 2022.
Okay. All right. Any response?
The main reason why I brought up the amended information and discussion, I guess, in Toro is because I think that would be actually necessary to understand the analysis in Toro. I don't think we can really extrapolate the specific parts of our arguments and compare that to Toro because we don't know what the allegations of when that bigamous or the crime of bigamy actually occurred. We don't have any dates in Toro. So if the dates listed in that information in count 1 were well outside of the statute of limitations, then that would be the reason why it could have been dismissed. It's not saying, Toro doesn't state we refuse to apply any sort of fraud standard to count 1 to that bigamous marriage, and so because of that, we're dismissing this for statute of limitations. We have a very brief, non-detailed description of we're dismissing this because of statute of limitations. And so, for example, if, I think it's Deborah, if wife 2 were to have known in 1991 and the amended information gets charged in 95, that's 4 years. That's outside of the statute of limitations. So that would still comply with the state's argument here that once the victim knew that a bigamous relationship or crime of bigamy had occurred, that's when the time would start tolling. So it would be that November 22nd, 2022, and the state would have 3 years. But unfortunately, we don't have that information for Toro, so we don't fully understand the reason for the dismissal other than the blanket term of statute of limitations. And so it's the reason why the state puts that information out is simply to, I guess, make the argument that we don't understand the details of surrounding the statute of limitations dismissal in that case to be able to apply it and say right here, right now, that the reason that the same situation is occurring in this case as in Toro.
And Judge, we don't have to do those mental gymnastics. The law is very clear. It's a 3-year statute of limitations, appointed crime offense. There is nothing in 775-15 that suggests that there is an extension for bigamy. Absolutely nothing. This is very clear, 3-year statute of limitations, appointed time offense.
apologize, it's going slowly, but we seem to be having internet problems, and I keep losing my connection, so I'm having difficulty reviewing the documents in the case. What I find interesting about Toro is it really focuses around 82602, the exceptions really, versus 82601. And Mr. Stewart and Mr. Gomez, as you know, I put my thoughts on the record. What I'm struggling with the argument we have here is the concept, essentially, that and we know, for instance, we have the older cases that say that, you know, you can enter into the marriage in another state, and as long as you don't cohabit in the state of Florida, then you can't be charged with bigamy in Florida, right? That's the case law. Those are old cases, but it appears to be still good law. That's what I was checking. And to me, that sort of casts against the argument that it's a point-in-time crime. Because you could be married in another state, move to this state and cohabit, and you read the dicta in those older cases, and it suggests that moving to this state in the bigamous relationship then creates the crime no matter when the marriage took place. And I realize there's no current cases that talk about that. But the court, in reading those cases and and listening to arguments, that sort of casts against that whole concept. And if we think about it, essentially, someone who enters into a bigamous marriage could successfully hide those marriages for the statutory period and never be guilty of any crime, simply because they successfully kept their wives or spouses, let's just say spouses, it doesn't have to be a wife, their spouses apart for the requisite period of time. And so reading the old cases together with the new cases, and I don't see that the 82601 case law is in derogation of the common law. It seems to be actually pretty much an adoption of the common law. So reading the cases together, I don't find that the motion to dismiss is well-founded. I believe that the most liberal reading of the motion as you filed it would have been possibly when the aggrieved spouse learned that, in fact, the marriage was bigamous, was a violative of 82601. That would be the most liberal reading. course, and therefore the information was filed clearly within the 3-year period of time. So the motion to dismiss is not well-founded and is denied.
And Judge, could you help me with regards to the other cases that the court mentioned surrounding the concept that the individual could engage in bigamous marriages and move in or out of the state, what constitutes a crime? I'm not sure if I'm familiar with the cases the court's referencing.
Yes, there's an older case that talks about is Davis, which is 76 Florida 459. And Catron, which is 40 Florida 468. And
I'm sorry, Judge, that was Catron?
Catron.
Okay. And that citation, I'm sorry?
40 Florida 468.
Mhm.
And then hold on, the last one was Wills, which is 63 Southern 2nd 184.
And Judge, just so I'm clear, for purposes of moving forward, the court is indicating that it believes this is a discoverable offense for purposes of statute of limitations. Is that correct? As opposed to a point in time.
Yes, I don't believe, I've recited my feelings, my view of it on the record.
Very good. Your Honor, I think we're on for the court's pretrial for the next case, or excuse me, for the court's next pretrial as it relates to this case.
Yes?
And what date is that, Madam Clerk?
3-9. All right, Madam Clerk?
Yes,
So-
Very good.
And do you believe we should proceed forward and be ready to set the case for trial?
Judge, I need to talk to my client and see how he wants to proceed forward. At this point, yes, of course.
All right. All right, very good.
Your Honor, that's all I have for this afternoon. May I be excused?
Yes, sir. Good
Thank you.
day.
Judge, may I approach?
Yes. Sure.
Back Home Bakery Cafe is 2 blocks from the courthouse on Crestview historic Main Street. We serve handmade pastries, espresso, and lunch items, and we're open Tuesday to Saturday from 7 a.m. to 4 p.m., serving lunch from 11 to 2. We hope to see you soon.
Hello, I am Bonnie from Body Be Healthy here in Crestview. We have been serving the area since 1999. We're an alternative health food store. If you're interested in bettering your health, we'd like to invite you to stop by. We're located in Court Plaza. Stop by and let us help you be healthy.
I'm Amanda Gaskin with Briar Patch Realty. Helping qualified heroes save money is my passion. When I help a hero buy or sell a home, they receive a check from Homes for Heroes. Check out amandasheroes.com for more information.
For more than 70 years, the sweet aroma of the Crestview Coney Islands burgers and hot dogs has permeated the downtown area. If you have not experienced the unique flavor of Crestview's Coney Islands burgers and hot dogs, then I encourage you to join us for lunch. Monday through Thursday from 10 a.m. till 3 p.m., Friday from 10 a.m. till 4 p.m., and Saturday from 10 a.m. till 2 p.m. We're located in historic downtown Crestview at 107 North Main Street. Call 850-683-1045.
Hey, I'm David at Family Vision of Crestview. We've been providing excellent optical service for Northwest Florida for over 34 years. Come in and let us take care of you.
Man, I got this. Let's roll. Fight fire with fire. Take 1.
Have you been injured in an accident and need righteous representation? Call us, because we fight fire.
Damn thing ain't working.
Whoa! Not cool, bro.
I'm attorney Coy Browning. Personal injury is no joke. Just ask him.
Injured? Take a breath. Call Coy.
or Pippin, whichever one.
Good morning. Get out here, Your Honor. Apologize.
Yeah, we need
Mr. Smith?
Excellent.
You tried.
Yes, Your Honor, this will be Mr. Flynn Smith, the fourth. We have two case numbers, 22 CF 1956 and 22 CF 962. And Your Honor, if I just may have a brief moment for a signature. Time, Your Honor. Your Honor, Mr. Smith and we previously went over, I have a plea form in my hand signed by all parties. It's going to be an open plea with a 10-year DOC cap because it has that 10-year DOC sentence. If I may approach with the plea form.
Granted. Raise your right hand for me, please. Do you swear or affirm to testify truthfully in this matter under penalties of perjury?
Yes, sir.
Okay, you put your hand down. You heard what Mr. Koch said, and you signed the written plea form.
Yes, Your Honor.
Do you understand by this plea arrangement that you're admitting the violation?
Yes, Your Honor.
And that tells me that you agree you violated your probation just the way the affidavit and report your officer files says you did.
Yes, Your Honor.
Do you understand by making this plea, you're waiving your right to a hearing where the state would have to prove your violation?
Yes, Your Honor.
Now, you understand that there's no agreement regarding your sentence other than you can't be sentenced to more than 10 years in the Department of Corrections on these charges.
Yes, Your Honor.
All right. And does that include any following supervision, or is it that's the total possible sentence?
Good afternoon, Judge Robert Lowe from the state. I heard the word cap. My understanding was it was a 10-year suspended sentence based on the plea agreement the defendant originally signed. So I don't believe there's a cap. I believe it's a 10-year suspended sentence.
Okay. All right, so, I apologize. All right, so is that what you understood? That it was a 10-year suspended sentence that was being at issue, and that your lawyer was going to argue that the suspended sentence shouldn't be imposed? Is that what you understood?
Yes. Your
Okay,
Honor.
all right. So to be clear, when I saw cap, then I got into it, but that's what we're talking about. You understand that there's this 10-year suspended sentence, and you want your lawyer to present arguments to me about why I should not impose the cap. Is that what you're saying?
Yes, Your Honor.
Okay. All right. But you understand it's completely up to me to make that decision. I'll listen to your lawyer's arguments, but you're leaving it up to me.
Yes, Your Honor.
Okay. Now, has Mr. Koch answered all your questions about the plea and how it affects you?
Yes, Your Honor.
Are you satisfied with how he's represented you?
Yes, Your Honor.
Okay, I'll find the plea is freely and voluntarily entered into, and I'll accept the plea.
Yes, Your Honor. If I may have testimony from my client, Mr. Smith.
Yes, he's under oath.
Okay. Mr. Smith? I want to really paint a picture for this court. So I know we entered this plea originally, but let's talk before that, just briefly, your growing up structure. Explain to the court, what was that growing up like?
I just grew up really poor and in a drug-infested environment with my mother, and my father wasn't there, and there's a lot of drugs and terrible times and fear growing up.
Okay. Did your mom and your dad had a drug problem?
Yes.
Okay. Growing up, did you know about Jesus or Christ growing up?
Yes.
Okay. Did you go to church with your family growing up?
They sent me to church to get me away sometimes, you know. That's how I started learning about Jesus.
Okay. Now, fast forward, you get arrested on these charges. Now you're in the Okaloosa County Jail.
Yes, sir.
Okay. This is before you entered probation with suspended sentence.
Yes, sir.
You were incarcerated for roughly around 7 months
I was incarcerated for about 28 months, I think.
before you entered this probation?
Before I entered this probation, yes.
Okay.
I did 17 in a regular dorm, and then I voluntarily went to the ECLC program for 7 months, and then went there and then started learning all kinds of stuff that I never even knew
Okay.
in my life.
And thanks for clarifying. So you spent 7 months in the ECLC dorm,
Yes, sir.
and that's run by Ms. Claude.
Yes.
Okay. Tell this court what it was like those 7 months. How'd that impact you?
Them 7 months, it impacted me very well because I learned to read in there. I learned all kinds of different classes, like how to set boundaries, freedom from addiction. I learned resolving conflicts, experiencing God. I did an anchor class on how to identify my true identity in Christ. I learned about characters. I read my first complete book ever in my whole life there, and did a 500-word book report on that, and did some essays. I did like hundreds of hours of class time in there, and learned so much about why I use drugs, and my past trauma is the reason why I was using drugs, and now I have a bunch of tools that I can use because I started doing the mastering the battle of the mind, like starting to think before I act and changing the way I think, and it just opened me up, and I got a good understanding of why I use drugs, and then how to combat them, and all the thoughts and everything like that. I'm just learning so much now.
Okay. And as you stated that you learned to read in Miss Dana Paul's program.
Yes.
Okay. And even our communications, you want to convey your thoughts properly in this courtroom. I know that's a concern for you.
Yes.
And you wrote down a statement you wanted to make, and you want to convey that to this court?
Yes.
Okay. Your Honor, with permission, may my client read that statement he prepared?
Granted.
Okay. Take your time.
Okay. Your Honor, I would like to say a couple of things on my behalf. I realize that I've made some bad decisions recently. Those bad choices took me back to my drug use, which caused me to test positive for methamphetamines. I did explain to my probation officer before being tested that I had been using meth. Besides the urine test, I have complied with all the requirements of my probation and participating in the ECLC class along with marriage counseling classes, and I was attending church on a regular basis. I had permanent employment along with a side business of my own. My boss of my full-time job said I can have my job back when released. I've also had a permanent residence and a vehicle. I've been married for 15 years, and my wife is still very supported, along with several other people who know that although I made some mistakes as long as I'm not using drugs, I can be depended on. I would like to say to the court that I had daily communication with my probation officer, Ms. Johnson, and when I was informed of the warrant for my arrest, I promptly turned myself in to the authorities at the jail. I turned myself in, Your Honor, in order to get help for my drug addiction. I need drug treatment, Your Honor, not incarceration. I know with proper treatment, along with, for my drug addiction, I need drug treatment, Your Honor, not incarceration. I know with the proper treatment, along with a good support system, I can remain drug-free once released. I tested negative for a drug screen at the county jail when I turned myself in, so my sobriety actually began before my arrest. My family needs me back with them as soon as possible. My wife is having to support herself while I'm in jail, Your Honor, And I would ask the courts to sentence me to a drug treatment program as an alternative incarceration. Thank you, Judge Stone, because I really do need help, and because I'm learning so much.
And I'm just going to ask a couple more questions here. Now, as you stated, when you found out you had a warrant, you turned yourself in to the jail?
Immediately.
Okay. Now, when you provided that urine and the sample, were you honest and open with them? Did you say it was going to be positive?
Yes, I did. I made a mistake, and I told them that I was going to fail the drug test.
Okay. And let's talk about that drug test.
Yes.
It tested positive for methamphetamine. Amphetamine is methamphetamine. Are you a drug addict?
I am learning not to be, though, yes.
Okay.
I got a drug problem that I'm learning how to deal with now. Yes.
Now, in your letter, and of course, I got you accepted in the KEAT program, and you're aware that could be 8 months to 18 months inpatient for your addiction.
Yes.
And that's that opportunity that you want to hopefully get.
That's the opportunity I need, yes, sir.
Okay. And then you touched on you've been married for 12 years.
And I've been with her 15, married for 12, yes, sir.
Thank you for clarifying. You have a vehicle on the outside, you and your wife?
Yes.
And you said you had a job, is that correct?
Yes.
What type of occupation?
It's a construction and like remodeling. It's for A and J Construction. Amadeus runs it. And I do remodeling and construction, maintenance, handyman, stuff like that.
Now, when you originally pled this case out, back in August 22nd of 2024, there was a 10-year suspended sentence, and I know this judge made it very clear that when there's a suspended sentence and there's a violation, it tells you right there that, hey, you need to do 10 years. It's a suspended sentence. I want you to explain to this court why should Judge Stone deviate from that? It's kind of like his word saying, I'm going to send you to 10 years. So why would he deviate from that?
Your Honor, this is the first time I've ever had the chance to even start learning about my drug problem. And I've been learning so much now, and I've got an understanding on everything that I've been doing until my drug addiction. Now, if I get the opportunity to keep learning, I think with the proper treatment, I can and will make it. And that's just, I'm learning so much, and I just want to stay sober and keep learning. I don't think incarceration is going to do it. I think that if I can get the chance to get some help, I can do this.
Thank you, Mr. Smith. No further questions from the defense, Your Honor.
Any questions for the defendant, state?
No, Judge.
Judge, may I confer with the possible other witness I have present in the courtroom?
Yes, sir.
If I may. I will not be calling any additional witnesses, but I just want to notate that my client's wife, Megan Smith, is present along with his mother-in-law, Denise Ellis, and they're present in the courtroom. So it would just be argument for defense. Your Honor, kind of as I was asking questions from my client, he signed on a suspended sentence and he knew a violation. It's black and white. But I first want to notate the score sheet when he pled out this case, and I'm not minimizing it for anything, but I'm showing 1 count possession of controlled substance, because my client is an addict, so he has 1 count prior to these charges, and he has 1 count of driving license suspended. Not minimizing that at all, and I'm not minimizing these serious charges. Just want to point that out to the court. My client is accepted into the Keaton program, and he does need inpatient treatment. I do like the fact that he was honest with Ms. Johnson when he provided the sample, that he turned himself in, and that he's continuing his ECLC, the training he's learned through the county jail.
I'm in there now, yeah.
Correct, and I know you're in custody now.
But I'm in the HCLC twice a year.
Good.
Right now.
Good. So, Your Honor, he's begging for that treatment for the Keaton. He has a wife. His tools he learned in our county jail, and that's why the defense is asking that for this opportunity to be sentenced to Keaton for that inpatient, bars to bed, followed by to reinstate all the probation terms and keep that suspended sentence. But I don't want to call this the second chance because he already had that. You gave him the chance. I'm just calling this his last chance, and that's what we're asking for today, Your Honor.
Judge, because of the nature of the charges, this defendant is a violent felony offender of special concern, so we need to conduct a dangerousness hearing under 94806 sub 8E. I don't know if the court wants to address the dangerousness first before we address argument for sentencing. I'll leave it with the court's discretion.
I think they run together, if you will, but you're right, because the violent felony offender of special concern statute does require the court to make that determination. And if I determine that the defendant does pose a risk, then the court's hands are pretty much tied with with the sentencing. And if the court makes the determination that the defendant does not, then the court has more options in the sentencing. So I think the appropriate way, excuse me, the appropriate thing to do is to cover the issue of dangerousness under 94806(8).
Yes, Judge. I'll start with just the statutory factors, the nature and circumstances of violation. This defendant did have a positive urinalysis for meth. This is the same substance the defendant was selling in the underlying cases. He was put on probation on August 22nd of 2024.
Actually, it was two substances, right?
What's that, Judge?
There was two substances he tested positive for.
Methamphetamine and amphetamine. I think they're derivatives of each other, but ultimately that's the same substance he was caught possessing.
Are they at the levels tested?
Judge?
Are they at the levels tested?
The levels that were tested according to the lab report were 500 nanograms a milliliter.
I'm reading the
Oh, I apologize, Judge.
4,593 nanograms per milliliter of amphetamine and 27,084 nanograms per milliliter of meth.
That's correct, Judge. I apologize.
I mean, I'm not a chemist or a technician, but based upon my history of listening to the testimony, when we have that level, it suggests the use of both different drugs, not a single drug.
That is
and
correct.
derivatives. Now, I might be wrong. I'll listen to arguments on that. But anyway, go ahead. I'm sorry to interrupt you, Mr. Little.
That's all right, Judge. And then the defendant violated in September of 2025, barely made it on probation a year before he tested positive for methamphetamine. Second, defendant's present conduct, including criminal convictions. Justice defendant has 6 felonies and 2 misdemeanors, manslaughter, possession of a firearm by a convicted felon, 2 convictions for possession of a controlled substance, 2 for sale, manufacture, deliver a controlled substance, and 1 for paraphernalia. Defendant is still using controlled substances, which is what he's on probation for, and ultimately what he sold the victim that led to the victim's death. Third is amenability to non-state prison sanctions. Judge, this defendant has a prior drug charge. He didn't learn his lesson then. Ultimately, he was caught on a traffic stop with drugs, which led to finding text messages and the defendant's confession, basically selling drugs to the victim. He was placed on supervision for a drug-related offense and still continues to possess and use controlled substances. He was given an opportunity on probation. He was given a gift. He squandered it. He already got a downward departure based on his plea with the 10-year suspended sentence. And then, of course, the weight of the evidence. The weight of the evidence is great. The defendant pled no contest, Judge, or pled guilty to the violation. Based on those factors, Judge, it's the state's position this defendant is a danger to the community.
What about the officer's recommendation and finding? The court's view is that the officer generally knows the defendant better than anybody, and what's the officer's recommendation?
The officer recommends drug treatment, Judge, but the officer, of course, his recommendation is not congruent with our criminal punishment code, and the primary purpose of our criminal punishment code is to punish. Second is rehabilitation. We tried rehabilitation already. That didn't work for this defendant.
And so you're advocating for the imposition of the suspended sentence?
I am, Judge.
Yes, Your Honor. I am looking at that same drug report that you mentioned with the nanograms and the different levels, and I'm clearly not any sort of scientist, but I understand that the different levels possibly using two different substances.
Right, and that's just based upon the court's history of listening to all that testimony, when...
And I just reference that's a fair statement that you just made, but just my client is clearly a drug addict, and Mr. Little is 100% correct. He blew that great chance that, like I said, I don't even call it a second chance, but on that back in 2024, that suspended sentence, getting the opportunity and the nature of these charges. But I want to stress on being a drug addict and kind of leaning into, as you stated, that his probation officer knows him more than me and recommending that treatment. And I didn't want to come in here today and just ask to let us out the front door. I wanted a plan in place. I believe a Keaton inpatient program. The facts that he was honest with probation officer Johnson when he provided that sample, that it is going to be a positive test. I have been struggling. That fact that he turned himself in, I know goes a lot of weight in this courtroom, especially leaning towards being not a danger, turning himself in, being honest with his probation officer. We are here not making excuses. My client provided a positive drug test because he consumed a controlled substance in violation of his probation, Your Honor. But turning himself in, being honest with probation recommending treatment, we have inpatient on the table. I'm pushing as he is not a danger, and I'm asking for that final chance. Understand that we blew a great opportunity back in 2024. So the defense's argument is he's not a danger, and we're asking for that inpatient treatment, bars to bed.
And as you know, I did not take this plea. This plea was taken by Judge Brown.
Oh, that's correct.
And so I wasn't here to hear what the state said, but I tried to listen to it in anticipation of today, but for whatever reason, I guess maybe the internet, I'm not sure, I wasn't able to listen to the plea colloquy. But it clearly shows from the, if I can get the document to open, I apologize. The score sheet shows that this was a downward departure based upon what at the time was the sentencing guidelines. And the way the plea agreement is written, and you said it, a suspended sentence should be there for a reason. And I'm a little more reluctant when I didn't take the plea and impose the sentence. But everything was there in place to support the defendant. If we look at if we look at what was organized, he was in the program at the jail while he was pending his sentencing on the underlying charges, and it appears that the judge and the state attorney took that into consideration by giving him the ECLC as one of the conditions if he were to continue that when he got out. But the hammer, so to speak, based upon the nature of the charge that he pled to, was the 10-year suspended sentence. And so I'm just reluctant not to impose it because it has to have consequences. And I guess that's what I'm struggling, why I should not comply with the agreement that everyone entered into at the time. And this is not like, it's not like a financial, it's not like something, it's a significant failure on the same grounds which led him to the place he was. Does that make sense?
Yes, Your Honor.
So why should I not do it? I guess that's really what I'm struggling with under the circumstances presented, since it's the same pattern and path.
Yes, Your Honor. My response to that would be, you're 100% correct. It was laid out black and white. It had that 10-year spent sentence. He had the support of, ECLC program. He was allowed to complete that program. My response would be that my client is an addict, and he hasn't had this opportunity of inpatient. As you stated, you weren't there when this was submitted. I wasn't there when this was submitted. He can't handle it on his own outside. He clearly needs to go inpatient, secure facility, and stay on this drug recovery. It's just kind of going to drug court when I fill in once in a while. We got to change people, places, and things. And these, unfortunately, I hate to call them hiccups, but these hiccups cost you massively. So my response is, we have a plan in place to send him to Keaton for that inpatient treatment. That's what I want to bring to the court, a plan in action at least, to tell you that it's not just shrugging our shoulders, but at least that inpatient treatment. And that last chance, as I kept saying, because you are right on that.
And absent the state's agreement not to impose it under the circumstances presented, and looking, and so, Mr. Smith, you should know that I treat every case individually. I don't have a formula. I treat every case individually. But there are certain things that I believe are important when we talk about pleas. And Mr. Koch understands that about the suspended sentences. The suspended sentences are there for a purpose, and they're there to be certain if there's a strong deviation from what would otherwise be a prison sentence, to be sure people are compelled to comply. I also understand that, addiction is not, it's a journey, and relapse is part of that journey for many people. It's not something that can simply be switched on and off for many people. However, if plea agreements and agreements by the parties are to have consequences, then they have to be imposed. And so I don't see a circumstances presented here where I should deviate from the agreement that the state and you entered into in order to avoid prison at the beginning, that I should deviate from that. And particularly with the violent felony offender special concern designation in the original charge. So I'll revoke and terminate probation, and I'll impose a suspended sentence.
And just for the record, credit time served, Your Honor.
Credit for all time served, yes, sir.
Yes, Your Honor.
There's nothing you can do.
Unfortunately not.
What about, do I get credit for my probation?
be a prayer for all time in custody, but not just being out.
Man. God. Come see me, please.
I'm sorry.
Judge, that's all I have. Maybe excuse me.
Yes, Mr. Bruno, thank you.
May I be excused as well, Your Honor?
Yes, please.
Thank you.
Good day.
Judge, thank you.
Good afternoon, Your Honor. Your Honor, before the court, Randy Catalinic, on behalf of Mr. Brian Walker Pippin, Your Honor, case number 23CF03. Your Honor, we're here basically for sentencing today. He has pled, Mr. Pippin has pled to the violation of probation, Your Honor, I believe about a month ago. And I've sent some letters to the court, Your Honor, in retrospect to today's sentencing, sir. What I would like to point out to the court, Your Honor, that's really important in this is he was on probation, Judge. He was given a 4-year probation sentence back in 2023. And he completed more than 2 years of that probation. And back on September 11th of last year, 2025, Your Honor, he tested positive for methamphetamine. And that was one time that he tested positive, Your Honor, and that was only one time. The state, Mr. A.J. Gomez, is seeking 1 year incarceration, Your Honor. We feel that that is steep based on the fact that he has successfully completed 2.5 years of probation, sir, without any incident. There was a victim in the original case. She has never been touched. She has never been contacted, Your Honor. And she is not part of the violation of the probation, Your Honor, but I understand that she's still the victim in the original case. While he's been in jail, Your Honor, he has had education by utilizing the EDIVO online education system offered to inmates. He successfully completed 28 courses representing 176 hours of study. Your Honor, I provided a list of those courses attached. He has remained productive while he's in jail by doing pool repair consulting via telephone with a business associate. If he's released, Your Honor, from jail, his job is secure. He's anxious to resume work as soon as he is released. Your Honor, he also owns his own truck and a fifth-wheel RV that serves as his home base when he is not working. He's current on his probation fees. His community service hours was completed with a payment of $624. Your Honor, we're asking that the court, he's had 420 days served. Your Honor, we're asking that the court either sentence him to community control. He's never had community control, or give him time served, Your Honor, and reinstate him back on probation, because he has never violated this probation with a new charge or contacting the victim other than this dirty urine on September 11, 2025.
All right. State. Yes, Your Honor, as Mr. Catalinic stated, the state is requesting a sentence of 1129 in the Okaloosa County Jail. As it stands right now, the defendant's score sheet with these 6 points for this violation stands at 43.4 total score sheet points. So he doesn't score a guideline sentence or presumptive prison sentence. However, I do want it to be known the main reason why he doesn't score is because of the score sheet guidelines that we have, and not putting any of a past history outside of a certain date on the score sheet. Mr. Pippin has been convicted of burglary of a conveyance with a battery possession of burglary tools and grand theft. Now I will be very forthcoming. That was in 1997, so it has been quite some time. I also would like to point out, this is the first violation in front of this court. However, if you look at the progress docket, there was a technical violation filed less than 3 months after this defendant entered into probation, where he tested positive for methamphetamine in December 20th of 2023. And so it's not the first time that he has tested positive for methamphetamine. He was given an opportunity at that moment, and he's lucky because had he gotten that in front of the court, he would be sitting here with a guideline score or a guideline prison sentence right now if we were to have added 2 of the 6-point hits for a technical or a non-new law offense. And so, Your Honor, in looking at the underlying charge, I think a 4-year probationary sentence was incredibly reasonable and fair for, in particular for the defendant. I mean, he threatened to, I believe the quotes were, gut the victim with a 4-inch blade, placing the victim in extreme fear of an immediate danger. Given the chance that he had with the original 4-year probationary sentence, the chance that he had when the probation officer actually didn't file a violation but filed a technical violation that never was brought before this court, and now we're sitting here, the state does feel as though a 11 months and 29-day sentence in the Okaloosa County Jail is more than fair. He scores 43.4 total score sheet points, which is 0.6 points away from scoring a presumptive prison sentence. And so we feel as though 1129 is more than reasonable given the circumstances of the underlying charge, as well as the new violation that he got in late of 2025 and the technical violation that was entered into this court record in December of 2023.
Your Honor, he's never been put on community control. Many people that come through this courtroom that have violations of probation are given a second chance on a violation of probation. They either get reinstated, they do a little bit of jail time, or they wind up in community control. If they fail community control, 9 times out of 10, they're sent to prison or jail. We're asking that he get time served, Your Honor, 120 days he's had in there, and reinstatement on probation. Even if the court decides to put him on community control, at least it will allow him to work.
Well, and he's a violent felony offender of special concern too, isn't he?
Yes, Your Honor.
Yes, Your Honor.
And in my reading here of the, he's been in, at this point in time, look like from 10/14, correct? Or 10/13 maybe? Is that right? On this present situation, right? Does it sound about right?
Yes.
Actually, 10/12.
Yes, Your Honor.
Just shy of 10/13, 11:52. All right. Any further arguments?
No, Your Honor.
All right. Revoke and terminate, no. Excuse me. Revoke and terminate probation, provide a year for after his release from jail to pay off all of his costs, sentence him 1129, credit for all time served on this charge.
Yes, sir. Thank you, Judge. That's all I have, sir. May I be
Thank you.
excused?
Good day.
Thank you.
Your Honor, may I bring a score sheet?
Yes. Let Mr. Catalinic review that.
Judge, I believe it's 43, is it, Mr. Gomez? 43. Yes, Judge, that's fine, no objection.
It's going all around. All right, anything else we're aware of? Did we cover it all, Madam Clerk?
What a day.